welcome to DawnNews English. I'm Nadia Naqi with you. Over 20 minutes, we're going to be discussing the case of the day, and that is that the Session Court, District Session Court, has handed 3 years jail term to a former Prime Minister and Chairman Tehreek-e-Insaf, along with a fine that has been imposed of 100,000 rupees. And this is in Toshakhana case. We have with us former Advocate General Punjab, Mr. Jehangir Jadoon Sahab. Thank you so much for joining us. Jehangir Jadoon Sahab, the basic question is that has the chairman of PTI been given a fair trial? Because, you know, until yesterday, we knew that Islamabad High Court has given its verdict, where this case had been transferred once again to the trial court. And, you know, my understanding was that there's going to be a couple of days that trial court is going to take a decision on this, because the plea of Tehreek-e-Insaf's lawyers were that they have not been heard. How do you look at the decision?
Let me tell you about the case. Actually, this was a case referred by the Election Commission of Pakistan. It was a case, a summary trial. It would not take a number of, a month, because the evidence has also been recorded in the Election Commission of Pakistan. But PTI, the case was referred to the judge in November 2022. But the PTI has not taken it seriously before. When they realized, the case is serious, and after the transfer of one of the judge, the current the judge has taken given the judgment, has taken over the charge. They speed up the case, and now the PTI wants we want to produce this one and that, the evidence and things like that. But the judge said we want to proceed on this case on daily basis. When the judge ordered that the case will proceed on daily basis, then the PTI realized that now it's difficult to escape from the day-to-day hearing. And then what happened is that finally, yes, I am of the opinion they can move to the High Court and the Supreme Court, because they have the constitutional jurisdiction, and they can take their points. We have not been given the fair trial under Article 10A of the Constitution. The reason being that one of the application which was turned down by the trial court, that you cannot produce your evidence, the witness, because the court has asked them to produce the witness till 12:30, and they said our witness are coming from Karachi and they cannot be available today. And there the evidence was closed, and now they have moved to the High Court, and High Court has given notice to the other parties, and the case was fixed for next week, coming from Monday. So one of the reason, although the case, right, I want to say this was the case are not merit. The case was merit. They have absolutely no case, but the technicalities they have raised might they have a case on the procedural irregularities or the procedural impropriety they have taken. And when the judges determined I have to decide the either way decision today, then it might take you, because justice is not only be done, but it seemed to be done. Obviously, they might get a chance. We were not given the fair trial, and under Article 10, they have to given whether they have no case or whether they have strong case. But the fair trial is the fundamental right of everybody.
All right, Advocate Jadoon, there are a few questions that I'd like to ask today. The court, took break about 3 times, and they were waiting for Tehreek-e-Insaf's counsel, Khwaja Haris, to come and, give his arguments. But by the time, he came, already the verdict was given, because the court said that we have waited enough. Does the court actually does this, or they could have just, probably adjourned the case? What is the procedure? Was it fair?
Actually, No. Actually, the thing was, during these summer vacation, the district courts is closed for 1 month of August, and they will open first week of September. And this trial judge, Mr. Humayun Dilawar, was, previously they was also assumed he will be leaving for the summer vacation. But he was asked to do the work till today is the last working day for him, and he tries the maximum he should hand down the judgment in any case today. Whether they have the arguments or not, but he was determined to.
Because it was his last working day, just because it was his last.
Yes, today was the last working day, because he is going for vacation from tomorrow, and he was determined to hand down the judgment in any case today, and that was the reason they might have, good argument in the High Court in appeal. He was determined to, finish the case in any case today. The principle of the law is you must give them the chance to everybody. But according to the record, previously they have given a lot of chance to the PTI. The PTI was not serious in this case. What I see in the future, because it was, the case, they might get, relief from the High Court, but actually the other cases against Mr. Imran Khan, which is a very serious case, is the Al-Qadr University, which is pending in the NAB, and he and his wife is on pre-arrest bail before the NAB. And there are a number of other cases like Cypher, like the foreign funding. Now, because they were not cooperating, to be honest with you, it was very difficult for him to come from Lahore, and he was not coming. And every day, in some cases, he was present at the court, but in other cases, because he has a lot of cases. Now, actual 3-4, which one the main cases, it will be easily for the courts, for the NAB courts, and for the if anyone court take the case of his Cypher, then it will be easy for them to go for the proceeding, because in the jail he cannot refuse to come to the court, he cannot refuse to give the his statement, he cannot refuse to the other evidence can be produced.
All right, so it makes it very easy for now him to shuttle between courts. He cannot run away, take time, because he will be arrested. He's already arrested. Now, there are questions that, one is that, the judge was going on leave, and you said that he wanted to hand over the decision before he leaves for his summer vacation. But just within a few minutes, I'd say probably 10 to 15 minutes, I really don't know the exact duration, because some say 10 minutes, some say 15, that, the Tehreek-e-Insaf chairman was arrested. I want to know that, is this how it is done? Because the warrants issued for his arrest were given to IG Islamabad, that he was supposed to get this done, right, on the court's orders. But the chairman has been arrested from Lahore. So what is the due process? Was it just, was the decision just WhatsApped to Punjab police?
In normal course, it cannot be happened. In normal court, because the person who wants to, they know what the judgment will come. They have make arrangement for everything, because it's not easy to pick the leader of the political party so urgently or so immediately. They are making the arrangement. From all sort of things. They know the judgment will come like this way, and they directed the police to be ready. And it's not easy that you get a warrant arrest to a police officer and he will immediately execute within few minutes. It's not possible in ordinary course of business and ordinary course of judicial proceeding. It will take time because in many cases, when the NAB court handed down the judgment of any conviction, they might look for if the person is on bail, is not present in the court, it might take consider proclaimed offender, or the police is hunting somewhere, because he was in his home. And I think they have told the Punjab police already this is the likely outcome of this case. Yes, and they were already ready to do that.
All right. Now, can he, because, his counsels have been saying that they're going to challenge the decision. Will this decision be challenged in Lahore High Court, Islamabad High Court, or can it go directly to the Supreme Court?
No. Actually, this the judgment, the conviction has been given to Election Act 2017. And under Election Section 190 of the Election Act 2017, they will file an appeal within 30 days of the announcement of the judgment, which is announced today. And after that, they have the 30 days time to file an appeal before the divisional bench of the Islamabad High Court. Only Islamabad High Court will hear their appeal against the conviction.
But they cannot directly approach the Supreme Court, as some of the lawyers had been saying that we're going to challenge this in the Supreme Court of Pakistan.
No, directly they can't go, because they've already gone to the Supreme Court, and Supreme Court said because let the order come from the High Court, because the hierarchy of the superior courts, and the appeal will lie before the divisional bench of the Islamabad High Court. And if the divisional bench of the Islamabad High Court take any decision, then obviously any party, both of the party can go to Supreme Court and appeal.
Is there any chance of him being, released on bail?
I think there's no, there's no chance he will be immediately released, on bail. Because if they move for the suspension of the sentence, and the jurisprudence and the law is that if you are handed down a certain quantum of sentence, let's say about 4 years, you must have gone about, 2.5 years or 3 years, then your sentence will be suspended. Otherwise, normally the court did not, would like to suspend the sentence. But if the judgment is suspended, they definitely they will request the court to suspend the judgment as well as the sentence. But normally, I think the court will take their appeal, and it's my opinion. I might be wrong. Maybe the judgment will be not suspended, or the court will say, okay, we will hear your appeal. Let the notice given to the other party, and the case will be proceeded on the appeal merit on the appeal.
And then whatever the outcome, then it depends on what is going to happen.
Yes. If the High Court decide other way, they can go to the Supreme Court.
So suspension of the judgment seems, the chances for it are.
Yes, chances are less, because the chances are less. They might have a good case on the merit, but if the appeal is decided within 2 months, then obviously after the appeal they can file further appeal before Supreme Court. But immediately, I don't think they will get a relief. He should be released on bail.
All right. Advocate Jadoon, tell me one thing. There were like yesterday, how the Islamabad High Court had given decisions on a number of applications, about 8 of them, that had been filed by Tehreek-e-Insaf on behalf of their chairman. There's one that talks about the evidence, and notices have been served. What about that? Because that is still pending, right? And this was about when the session court had said that these were not relevant evidences. So there won't be.
Actually, I've just told you they might have a good case on the procedure irregularity. Because the application is pending in the High Court, and the High Court given the notice, and they would have a good case because the High Court given the notice, and our defense evidence was not given priority, or it was totally discarded, because we want to produce the witness in evidence whether they have recorded or not. And when the judge you consider that their evidence is not reliable, they might have given the judgment their evidence has been discarded on the following reason. But at the moment, they might have, one of the good point, their evidence was not considered by the trial court, and against that, they have already, before the High Court, and High Court given a notice on that application.
All right. In the beginning, you had said that, maybe Tehreek-e-Insaf's counsels, or probably Tehreek-e-Insaf chairman, did not take this case seriously, and they had wasted a lot of time. When you say that, could there be a different judgment altogether had he taken the case seriously initially?
No, I mean, if they have taken the case seriously from November 22, this case now might have gone to the High Court in appeal, or might go to the Supreme Court in appeal. They wrap up the case. Case was of summary trial nature. They have intentionally delayed. Now, because the elections are coming, and if he is sentenced and convicted, they might tomorrow on Monday or Tuesday, the election commission may disqualify him for a further 5 years. He cannot contest the election, the coming election. It was actually from that point of view, I said, if they would taken the case seriously, now the case might have gone to the High Court or Supreme Court, and a final judgment may have come from the Supreme Court whether this case is on merit or not.
All right. There's a lot of confusion regarding his disqualification. Many say that this judgment by the session court is not about disqualification. This disqualification can only be decided once all the appeals filed by PTI, a decision on that has taken place and is not in favor of the chairman. Then only is that maybe the Supreme Court can give this. But according to the Election Act 173, this is not a disqualification judgment.
No. This judgment is not a disqualification, but he has been convicted by a court in an offence. And when you are convicted in an offence, you are disqualified to be a member of the National Assembly, or you cannot contest the election because the conviction has been handed down. This judgment is not disqualification. Disqualification will come from the Election Commission of Pakistan under Article 63 of the Constitution of Islamic Republic of Pakistan.
Oh, so which is an automatic disqualification, because that's
This
what.
is- No. This is not automatic disqualification. Disqualification is under the constitution and the law, and they with the conviction, you see the sentence, and the judgment will refer to the Election Commission of Pakistan, and obviously the Election Commission will decide he is not qualified to be member of nations.
All right.
Thank
Now, there's one thing that I would like to ask you, because, a lot is being said about these trials. How it is happening now has happened in the past. Do you see any sort of comparison between this case, how it has been dealt by our justice system, and the Panama case? Do you see any, can you draw a parallel?
I think Panama case was totally different, because you see the Supreme Court of Pakistan, the highest judicial forum, and the establishment was on the same page. And they also, you see, appointed a monitoring judge, and Supreme Court was directly involved under the trial process. That was very, very serious. And you see, as compared to that case, this case is totally different. It's not, you see, that's much, you see, because now the Supreme Court is totally, you see, I can say the neutral, or they're not favoring, you see, anybody. But at that time, the entire Supreme Court was, you see, and the establishment was on the same page. And in any case, they want to depose the Prime Minister. And the reason was that they just find out Akama. Instead of Panama, they find out Akama, and they disqualified elected Prime Minister without any valid reason. And that judgment will never referred in the history of the judicial jurisprudence as a precedent, you see, in any case law.
So today, you feel that our entire institution of justice is pressure-free, and there is no, forces that coerce them to take a decision like they did last time with Nawaz Sharif.
No, I said the judiciary and the establishment at that time was on the same page. They might have seen, I can't, totally ignore the thing. There was no pressure from some quarter. They might have, because if you presume or you expect this judgment will definitely come, then there is obviously something, fishy somewhere. Then I can't say with conviction that there was no pressure. There might be some pressure. The person who wants to, you see, there is a long history of the Pakistan. If you look from 1947 till date, there was, you see, the Prado and the Abdo and the Tisab Act and the NAB ordinance and things like that. That things, you see, going on and on in the history of Pakistan, and number of, you see, elected Prime Minister have been shown the door by the, you see, the establishment.
You must have seen on social media, there has been a lot of discussions, and even amongst the journalist fraternity, that why is it that always it's going to be a politician, a former prime minister, that will be barred from participating again, will be sentenced, handed over some kind of sentence. The accountability is only for politicians. Would you agree with that?
Yeah, sure, because you see, they face the accountability. But the master, the king who are managing these things, they are, you see, exempted, and till to date, no court is, you see, or no executive is able to produce them before the court or give them some punishment. Even, you see, in the case of Musharraf, although you see the conviction was handed down, but it was not executed, because the execution was really a difficult task even for the court. And finally, the court which given the judgment was, you see, abolished by a judge of the High Court. At that time, even the High Court of Lahore has no jurisdiction. But despite of that judge, you see, handed down the judgment, and they, you see, totally consider void ab initio the special court established at Islamabad. I will agree with you that was not, you see, I don't see in the history the person who is a kingmaker and who has the actual power in their hand. They have never been penalized so far.
My God. And so such is the accountability in our history. But thank you so much for your time.
Thank you.
Thank you so much for your time. Former Advocate General Jehangir Jadoon, for being on 20 Minutes with us. That's all for now. Goodbye.